Welcome to Legally Speaking with me, Tarun Nangia. Today, we're going to discuss the third part of our series on the comment that Justice Chandrachud, the Chief Justice of India, had made much earlier, where he's been echoing this sentiment. What he said, that social media thinks that every remark that a judge makes is a judgment. And this theme carries on. Why? Because many times judge, in their pursuit of finding out truth, may ask questions in court, and they are criticized without any basis or reason, without people who are not informed of what the judges say. And it really impacts the court because the criticism many times is without basis and very ruthless and in poor taste. There are a lot many things that are said, memes are made. Why this is an important issue is what we're going to discuss today, and how it affects court functioning, because we all live in a society which is connected. Nobody can be aloof from society, even the judges. Obviously, they are part of a society. They are not apart from society. I have with me Tahira Karanjawala, who is with one of India's leading law firms, Karanjawala and Company. Good to see you, Tahira. I have with me Neha Nagpal, partner with NM Law Chambers, a law firm she co-founded. Good to see you, Neha. I have with me Archit Singh, who is with Circle of Counsels. He practices at the Delhi High Court and Supreme Court. Good to see you, Archit. At the outset, may I request Tahira to lay the ground of this issue before we move ahead. Tahira, over to you. What did Justice Chandrachud say, and what are your few initial comments on this issue?
Thank you, Tarun. So I actually think that the comment made by the Honorable Chief Justice was a very fair one, and it actually throws light on a very important issue and what is quite a relatively new issue today. I mean, this actually results from two things. Firstly, social media today has become this robust platform for freedom of speech and expression, and rightly so. But it at the moment is a slightly unguided platform. It requires absolutely no qualification for a person commenting. The second aspect which has given rise to this problem is that there is an increased access that the public has to the legal process and the justice system. By and large, this is viewed as a very good thing and has been encouraged by the judiciary as well. It was expedited because of COVID and virtual hearings. And now the judges have in fact allowed live streaming of matters of public importance and constitutional importance. And in the hope that this will translate into a greater awareness of legal rights and a better understanding that the public has of the justice system. But what it has also done is resulted in a situation where today the public has access to watching judges even when they have not fully developed their thought process on a particular issue. Every offhand casual remark is is posted about, is discussed threadbare, and often in a very uninformed way. And I think that was what the learned Chief Justice was pointing out when he made that remark. This actually has led to two major problems, in my view, as far as the legal profession is concerned. Firstly, any counsel will tell you that a silent judge is a very daunting prospect for a counsel. A counsel any day prefers a judge who is expressing their mind. Often what you think are comments are actually in the nature of questions and inquiries. And when a difficult question is posed to you, you have the option of explaining to the judge what your stand is on a particular issue. If this was not to be done, then you will have a situation where a judge may simply say, okay, thank you, and dismiss your matter without giving you a chance to explain. So a reticence or any sort of hesitance by the judges to ask questions is only negative for your case and for the counsel arguing and for the profession. And the second problem that I feel it has caused is that there is now an increasing spread of misinformation because of some uninformed people who post about the comments of judges. A judge's final view is only reflected in his judgment. When a judge writes a judgment, he sets out the facts, he sets out the contentions of the parties, the reasoning. It is only when you read the judgment that you get a holistic understanding of what that issue was. When a counsel argues before a court, they have read the paper, so has the judge. So the discussion starts on a premise which is at a certain level. Any person watching the proceeding may not understand the context. Even trained lawyers or trained legal journalists may not understand what is happening in a particular case when you don't have access to the papers. So any person sort of just watching this proceeding, picking up on a particular comment and posting it, often this doesn't reflect the final opinion of the judge. It's a very premature view of the judge. And then this leads to a sort of case of Chinese whispers, because there are people who are only watching Twitter. They're not reading the judgment or even watching the proceeding. They are only watching what is happening on Twitter. So their knowledge is even less. And then it leads to this sort of increased this sort of uninformed debate, which may be proceeding on a completely wrong premise.
Point well, very well taken. Nice set of points given by Tahira. I'll take this to Neha Nagpal from NM Law Chambers. Neha, two things: ball by ball reporting. Every half a comment that a judge makes finds its way to social media. Practically not even the full comment, because judges tend to make longer comments many times. Half a comment, and people give their opinions on it. Many times, even well-educated people are not known to having read judgments, forming their opinion on basis of what they have read on social media. Do you think that it's not easy for the judiciary also to be faced with all this? Because in the end, the judges can't speak for themselves. I mean, they don't go out and issue a statement like every politician every evening that this guy said it wrong, that guy doesn't know what to say.
So I think, first of all, Tarun, thank you for having me on your show. It's always a pleasure. Tarun, I think that what the Honorable Chief Justice of India has very succinctly put out there is a very strong message that, look, it is only the judgment of any court that is worth the paper it's written on. It is sacrosanct. Only follow that, because that is what their lordships are communicating or laying down. During the course of any exchange, it is very important to ask questions, and also, as Tahira put, and I firmly believe, as a lawyer, I've learned there is no right answer. There is a right question. And in that quest to do substantial justice, I think it's very important for judges to ask questions. And many a times questions don't really come with that question mark. They can also come with an exclamation mark. That does not mean that it has to make its way to social media and become a hyperbole out of it. It is in aid of their process to even get the truth out of the, I can't say truth really, but to get the real facts out of the councils, even the law out of the councils. One stray comment here and there is not the ratio of a judgment. It's not even obiter. Obiter and ratio also come in the judgment. So this is just the process of a judicial proceeding. And I think the time has come where we need to be slightly more responsible towards what gets reported and doesn't get reported, because today you have virtual hearings. So a hearing is open not just to lawyers or the client present in court. It's all we also have live streaming. So pretty much it's going down for posterity. And we can't be at places where loose comments are then string a Twitter debate or something on, a court somewhere gets calls for a debate, because that is only going to influence the judicial process. And I don't want to take it as far as saying that's contempt of court under the Contempt of Court Act. But what I'm trying to say is that it leads to the following two things. One, you are blowing one simple comment out of context. What is the client, what is the counsel who's arguing before the bench trying to present? Nobody has put that there. And so it can come to a third person as oh my God, this judge is so negative towards something. That may not be the case. The judge is just trying to, like a sitting judge of the Delhi High Court had once made a comment on, women lawyers practicing, and how that was totally blown out of proportion, because that's not what she meant. For heaven's sake, it's a woman judge who made that comment, and she's also been practicing a lawyer before she became a judge. So what I'm trying to say is that one has to see the context in which it's said. Therefore, Justice Chandrachud clearly meant that read the judgment, wait for the judgment. You will get the meaning from the context in which it is said. And as lawyers, we know that that's how we distinguish judgments. That this in this case meant this because that was the factual scenario. Secondly, it creates a massive problem with clients. Something that solicitors and briefing counsels as us have to distracts us to a point which we don't know what to do, because a client becomes hypersensitive. Oh, you didn't tell us this, but we read this on social media. we can't let our matter go before this judge. What will happen? We'll sink. But it's not like that. And therefore, you get distracted from really dealing with the matter and then dealing with externalities, which are so not relevant to anything. It's going to be forgotten in no time. So I think there calls for a little bit of caution, not at the hands of the benches or the councils, actually for those reporting live from court and starting these strings of conversation on Twitter.
Thank you for beautifully explaining and putting this in perspective, Neha. And I remember once a judge said, "What the hell is happening in this country?" But it was in the context of a particular matter.
Yeah.
The newspaper headlines read, "What the hell is happening in this country?" is what that judge is saying.
Exactly.
Know the kind of pressure that would have been brought upon that judge, because it imputed that he was talking about the country as a whole and not about a case. And it is unfair to the judges. I'll go to Archit Singh, advocate from Circle of Councils, for his opening comment.
So, Tarun, as you know, I've been always a big proponent of criticism of any wing of the state, be it judiciary, be it the political side of it, be it the executive. I think in a democracy, everyone is subject to criticism as long as it is constructive. Now, I think Justice Chandrachud's remark, considering the context and the place in the society we are in currently, we are a developing society. Social media has currently been a buzz with the way legal news is presented. Now, over here, we have to remember DYC, Justice Chandrachud, is not asking for censorship. He's not saying that, hey, you should not report things. He's saying, but when you report something, there is a sense of responsibility that comes with reporting things within a court as well. Because a layman sitting at home reading, we are a society of fast media consumption. We see 8 words in a Instagram post or an XYZ Twitter post, and we think that is what is a judgment or that is what is going on in court. But that is just a part of the entire thing, of an entire debate that is going on in court. So unless that context is brought to the attention of the people, unless the entire debate is brought in the right perspective to the people, there will be problems that will continue. Now, I remember when I was in college, at that time, social media wasn't prevalent. People would go into the court, the reporters would go into the court, they would rush out of the court, go back to their editors, the newspaper would then debate, the editors would sit with their team, the news would then come out in a reasonable manner, taking all things into a context. But today, there are live updates that happen. Now, when live updates happen, people are not able to get a sense of what is actually going on in a court, because it can be a haywire out of context. So-and-so judge said so-and-so thing. But in what case? Regarding what? What was the discussion that was going on before the judge? What did the lawyer say? What is the subject matter of the entire discussion? That is something which often loses context. And when these things are not brought to the attention of the people, there we have problems. And this is more so a problem when a journalist house, say a media house, reports X, and then that is picked up by the media in a furthermore narrow way, or the social media. People start, they pick out things, and there could be various reasons why they're picking out. Something suits their agenda, something else can be the reason, but the way it is done, it's very important. That is where I believe that Justice Chandrachud's comment should be taken in the sense that it is not a call for censorship, but a call for responsible reporting as well.
Call for responsible reporting is what Archit Singh says, and should be taken in the positive light. Thanks for giving that different perspective. You're up for criticism in a constructive way, but
yes,
you're also saying that responsible reporting is also an element of all of this. I'll take this to Tahira Karanjawala from Karanjawala and Company. Tahira, what is the dilemma of a judge today? See, I'll tell you an example. Many times I see that the judge, one single line comes and the judge has taunted a lawyer. Maybe about 3 minutes ago, he has praised the lawyer. And this is all about what we call as court craft. It is court banter. A lot of things are understood by the counsel and by the judge. And the meanings of the words are entirely different in court as to what they are taken outside court. So what is the dilemma of a judge today?
So, Tarun, actually, what you've said is a very important thing. Our profession and the way that it's structured, it's an adversarial system, but I mean, the whole point of a hearing is that lawyers and judges interact openly and interact frequently. So as you correctly said, there may be something said between a judge and a lawyer, which is in the context of something that happened the day before, or in the context of some other case, or in, sort of there's banter, there's, it's
Yes.
a judge may take off a lawyer. It's not, everything is not supposed to be blown up into a, sort of massive proportion and then reported. And then, as Neha correctly put, it leads to other problems with clients, people
Yes, yes, yes.
misinterpreting, how well the lawyer argued, or, how that, this lawyer doesn't go well before this judge, we should not take him. It leads to other problems which are frankly not relevant to your case, actually. And I mean, I'll give you a small context. Now, what often happens, if you approach the Supreme Court directly in a 32 petition, so if you can come to the Supreme Court or the High Court to enforce your fundamental rights. Now, often if you come in a direct 32 petition to the Supreme Court, the court will say, why have you come here? Why don't you go to the High Court? Now, sometimes what happens is that's picked up saying, Supreme Court says, don't come here for justice, or something like that. Somebody will report it wrongly. Actually, you're supposed to go to the High Court. A judge saying that is only actually reinforcing what the law already is. But this is the kind of comment that if you take out of context, and people, we are lawyers, we understand that this is the context. A trained legal journalist will understand, or will do due diligence to find out. They will try and get hold of the pleadings, or, sort of at least you speak to the lawyers concerned. But a layman, doesn't have this context. So I think that the least one can do is, if you want to, and look, everybody is pro freedom of speech and expression. If you want to comment on social media, then the least you can do is do your due diligence, read the judgments if they're available. And if they're not available, at least try and understand and ascertain the context before you post. And I think this is something that will take this whole system some time to absorb. And I think what, the Chief Justice has said is a caution, and is guidance in the right direction as far as how to absorb legal news is concerned.
I remember once in the Chief Justice of India's court, one former law minister and one another very former minister, who are both senior lawyers, they went to mention a case, and the Chief Justice of India denied mentioning. Then a lawyer in his 90s again went up for mentioning, and the Chief Justice of India immediately retorted back, anything for the Bhishma Pitama. So in a way, he was allowed mentioning. The whole issue was construed as that these senior lawyers don't get any audience in the Chief Justice's court, but this gentleman gets. It was just a very warm gesture by the Chief Justice for this lawyer who barely comes to court in any case because of his age. But even these things can get misconstrued. So, what is understood in court among lawyers and judges is a whole new world and a different world for the outsider, who then, via his access to media, claims to know much more than he does. That aspect is very, in a sense, disturbing also, because it doesn't represent a true picture of what's happening between the lawyer and a judge, and that banter means something entirely different in court craft. I'll take this to Neha Nagpal from NM Law Chambers. What's the dilemma of a judge, Neha?
I think we are putting another layer of, by we, I of course mean the pressure of the social media on judges sitting on the benches. They're anyway burdened, maybe even overburdened with the volume of cases, with the tough job that they have of, balancing equities, of delivering justice. And here today, we're adding another layer of complication and burden on that by saying, listen, also be very careful of the questions you ask in court, because somebody is going to post it and it's going to become a halabaloo out of. I think we need to be sensitive to the jobs that judges are doing. It's not easy, especially in a very burdened system as ours. In a system where most of the times you have people coming to court who cannot afford litigation, who cannot afford to go to the higher court. I'm not talking about clients most of us here represent, but I'm talking about literally the common man in this country. If one, as I am very often on the criminal side in the Delhi High Court, and you see the hours benches spent on, quashing petitions which arise from matrimonial disputes, and how they have to undertake a very pressing role there of, literally getting, asking the clients in, the petitioners, the respondent in person, about the state of the settlement and whether they're bona fide doing this or under pressure. And to do that, they need to ask questions, they need to make comments, they need to push a little bit. We have to be very mindful that here there is no assistance that these judges are getting. They are doing this to be able to, deliver what they are sitting to do a good job, to keep up to the oath to the Constitution of India. So I think be acting irresponsibly and just for somebody to get more followers on social media to do this is not fair. You are somewhere disturbing the process of administration of justice, and which is a cause of concern. And I think the Honorable Chief Justice is very, as articulate as he always is in his judgments as well and in court, has very subtly put that warning out there.
In fact, Neha, in your previous answer, you also mentioned one thing that clients misunderstand.
Yes.
Banter between a judge and a lawyer.
Yes.
And the clients may claim to know more than they actually know in terms of, oh, but this judge said this to a lawyer, so maybe not happy, not understanding that that's how judges and lawyers talk. They have a different way of addressing each other, different way of commenting.
Sometimes lawyers, we are felt saying, oh, really? I mean, we didn't know this, but thank you for the information. But it's actually misinformation because it comes from somebody, not a judicially, legally trained mind, and it's only going to affect their own case. And it really does happen. And one sees it happen more often now than maybe 10 years ago.
Point well taken. I'll take this to Archit Singh from Circle of Counsel. Archit Singh, your comments on dilemma of a judge today.
So, Tarun, I've had the privilege of working as a clerk in the Supreme Court with a judge. And with that context, I can say that, when a judge comes to court, and I think as Neha and Tahira have also pointed out, that the pedestal and the context with which a judge and a lawyer are often talking to each other, there is already a sense of understanding of the matter. There is a lot that goes behind the scenes. A judge often comes very much prepared with the case. They have read the files, they have done their own diligence on the matter as well. And when they come to court, they are prepared with certain questions. Like, they have certain queries in their mind. So often these queries are straight away presented to the lawyers as well. There have been times wherein a lawyer will just enter the court and the judge is prepared in his mind that, okay, I understand the facts, I understand these things, but I need certain clarifications. And these clarifications are sometimes taken out of context. Now, this will lead to a situation wherein the judge will start saying, hey, I'd rather might not just ask a question. Like, what is the point of asking a question if I ask a question and tomorrow someone else is making a hoo-ba-hoo out of it, a big ruckus out of it, that why did I ask XYZ questions? But these questions have a point to them, which is something which a layman does not understand. But we as lawyers do understand that when a judge asks a query, there is a sense of responsibility with which those queries are also often asked of a lawyer. They are trying to ascertain a sense of truth. So when these stories are taken out of context, it does affect the functioning of the court as well. It does affect not just lawyers, but the functioning of the bench itself. And that is not conducive to independence of the judiciary or the functioning of judiciary itself. So I believe the way things are taken out of proportion does impact the way the judges also will come to court with the kind of questions they have. Because sometimes they are pointed questions, sometimes they are critical questions as well. And they're questions of law, they can be questions of fact. And I sitting on the side, as Tahir had also pointed out, I'm a lawyer, I'm trained, but there may be a case I have no idea about. There may be a case I have no context about. And when the debate is going on between a judge and the lawyers, I may take it to be something else. I may just take a question of law and say, oh, maybe the judge is trying to apply it wrongly, but I don't have the analysis of the facts which a judge and the lawyer at that point of time have in their debate and their discussion.
Okay, point very well taken. As has been pointed out now that a lot of people on social media may use hyperbole in criticizing a comment made by a judge. That's not the problem. Many times the problem is that lots of money is used to troll judges on social media. It can't be possible that thousands of people write the same comment at the same, very same instance. And it seems like it is an organized trolling of judges. They can't, they have family members, everybody has family, everybody has friends. Feedback does come. We may say a judge should live in ivory tower. I don't think that's possible in today's world. You can't be isolated from society. In fact, it is a dangerous prospect to have a judge who's isolated from society, which means all feedback mechanisms are cut. How will he pronounce judgments if he's disconnected from society? Keeping this in mind, we're going to take a round of final comments. Tahira, your final comment on this issue.
Thanks, Tarun. So I think my final comment is again that I think what needs to be kept in mind is responsible comment by any person who chooses to comment. So the least that one can do is ascertain the context in which a comment was made, hopefully wait for the judgment, and try and keep criticism of judges to a bare minimum. I mean, I think this is something that was always taught to us, that one can criticize the judgment but not the judge. Today you cannot have a situation where judges, fortunately there judges of the higher judiciary are very well trained and are very sort of withstand this kind of criticism. But the last thing that you want is a judge feeling that they need to cater to public opinion. You must remember that a judge is not responsible to the public in the sense that a parliamentarian or a politician is. His or her only job is to uphold the constitution and to uphold the laws of this country. Often a judgment may not be something that's popular, but it may be legally correct. So this is another thing that we have to understand, that judges should not feel, and certainly should not be treated like politicians. They should not be expected to do what is a popular thing. Their only responsibility is to the constitution, and it should be kept that way.
Thanks for the closing comment. I'll go to Neha Nagpal from NM Law Chambers for a closing comment.
So Tarun, I definitely think that we have to come of age in terms of social media has to come of age with not just being responsible, but also striking a balance between dissemination of information, responsibility, and the context of which things are said in. We cannot, this treadmill of rush of dissemination of information somewhere has to stop. And maybe it is time, while live streaming is allowed, while virtual courts are allowed, maybe we need to sort of have a debate on this, that should there be some limitation, because even Article 19.2 of the Constitution says that while we uphold under 19.1G, we uphold free speech, but 19.2 puts in limitations to that. Is it time to consider limitation that in at least some sensitive cases, there can be no media reporting, or there can be no live reporting of comments made? Because it does put pressure. Like you said, no judge should live in an ivory tower, because Supreme Court has repeatedly said that the Constitution is an evolving document. If it has to remain an evolving document, the judges need to be also in sync with the change in society, the outlook that is developing. So I think maybe it's time to have some sort of open ourselves to a debate where there is some method, some rules and regulations that have to come into play.
Thanks for the closing comment. I'll go across to Archit Singh for his closing comment.
Thanks, Tarun. Tarun, I think we have to always remember that we are living in a very new era of social media. This is something the judicial fraternity, the legal fraternity itself is not used to. It is an opening of the way the conduct of the court is being portrayed to the people. Now, it is very hard. And now we all know the way social media functions. We can probably have guidelines when it comes to reporting, but it is almost impossible to stop each and every person in the country to not say certain things. Also, that being said, we, as you had rightly pointed out, we also have trolling in this country that is highly prevalent. So I think that is one aspect that we need to really recognize and see, can there be some sense of guidelines that can probably also be issued to ensure how trolling can be curbed? Because trolling is a big issue, and it does not come out of genuine people doing it. It also comes out of where fake accounts are created to take certain agendas forward. So how can this be controlled? And if I think this is controlled, 50% of a problem can be taken care of over there. The rest 50 will take time, and as all things do.
Thank you so very much. With this, we bring to an end the 3-part series on what Justice Chandrachud said about comments being, in a sense, misunderstood what judges make and social media passing judgments over it. Also, the fact that we really like and we cherish when our judges speak, when they are vocal, when they come out and interact with the public. That in a sense humanizes the judiciary. There is a human element to it also. It brings judiciary closer to the people in that sense. When they know their minds and they speak out their minds, it is impossible. It is in a sense very important to have these kind of judges, and we are lucky that in the past few years we have had many such judges. Justice Chandrachud being a prime example of how openly he talks about so many things. It gives us a view into his mind and what he thinks, and instills a sense of confidence. And what the Chief Justice Chandrachud said, that the Supreme Court is not the court of Tilak Mark, but it is for the entire country. That was indeed a very, very deep comment for many who have understood what he meant to say. We shall continue to follow what he says, and if possible, do these kind of discussions. Thank you so much, Tahira Karanjawala, Neha Nagpal, and Archit Singh for making time and joining and decoding this issue for the viewers. Thank you so very much.
Thank you for having us, Tarun.
Thanks, sir.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.